My name is Kathleen Scott, and I'm a counsel here at Arnold and Porter's New York office. And I would like to welcome all of you to our latest in a series of financial services regulatory roundtables. Today, it's not just registration, new regulation of swap transactions by U.S. and non-U.S. banks under Dodd-Frank. I need to read a disclaimer. For those who are participating via web, please use the chat feature tool within WebEx to ask questions throughout the program. If we have a chance, we'll take them during the presentations. If not, we'll answer them at the end. If for some reason we run out of time and we can't get to your question, we will answer the question afterwards because you should have all of your contact info. Your lines have been muted. However, if you ever need assistance during the conference, you can just press star, then 0 on your telephone, and a conference coordinator will be happy to assist you. This event is being recorded and will be posted on the Arnold and Porter website, where it will be available to the public. So anybody who speaks will be recorded. And for your convenience, shortly after the program, we will send a link with the presentation materials to all of the participants in today's program. So we have a lot of ground to cover. I am just moderating and keeping things running on time. My colleagues here today are 3 people who definitely are in the know about all of these things that are going on. Title VII of Dodd-Frank, dealing with swaps and derivatives, makes sweeping changes to the law, and it's been a topic of interest and great interest in the financial services community. My colleagues today, to my immediate right, is Andy Scheip. He's a counsel in our financial services group. Next to him is Dan Waldman, a partner in our DC office with a derivatives expert. And last but not least is Mike Griffin, a partner here in New York, who is hedge funds expert. So we have some slides, and as you can see, we have the agenda, basically sort of a rough agenda. We'll go through the background, and then entity and product definitions, some extraterritorial issues, and an overview of record-keeping, reporting, and compliance issues. So without further ado, I'm going to turn it over to Dan Waldman, who's going to start us off with background.
Good morning. Following the financial meltdown of 2008 and 9, there was general consensus among policymakers in Washington, I think, that the largely unregulated OTC derivatives market had contributed in some way to the crisis and to the need for the financial taxpayer bailouts. And as a result, one of the principal objectives of the Dodd-Frank Act was to regulate the swaps and derivatives markets more effectively, and that effort you see reflected in Title VII. It's over 100 pages of legislation that is in almost every section calling for further implementing regulations from the various regulators, principally the CFTC, SEC for securities-based swaps, and the prudential regulators vis-a-vis the financial institutions that they regulate. The central principles of Title VII, I would say, fall within sort of 4 categories. The first objective or principle is to impose a comprehensive regulation over swap dealers and major swap participants. These are the largest and most active participants in the swaps market, and there was felt to be a need to regulate them in a relatively comprehensive fashion with respect to their swaps activities. And you will hear from both Mike and Andy a good deal about how those provisions are being implemented. The second important objective of Title VII, again reflected throughout that title, is an interest in policymakers in moving the primarily bilaterally negotiated swaps market into clearing or through clearing houses and onto exchanges. So essentially to require additional clearing and exchange trading of swaps, particularly obviously those that are amenable to clearing and exchange trading, which would be the standardized and most liquid of the swaps products. The third, I think, general objective of Title VII is increased transparency both to the public and to the regulators, and you'll see that reflected in a wide variety of provisions in Title VII. I think clear fact was that the market was too opaque, particularly in times of crisis, and as a result, you'll see a lot of new reporting requirements. And the final category, maybe more of a catch-all category, is enhanced regulatory authority to the regulators. Again, perception was that the derivatives markets generally were not being adequately supervised. It wasn't enough oversight by the federal regulators. And there are provisions that enhance that regulation in a variety of ways. There are a lot of new rules applying to existing exchanges and clearinghouses, including rules that permit the FSOC, the Financial Stability Oversight Commission, to get involved where the clearinghouse is viewed as systemically significant. You also see additional oversight over the physical commodity markets, energy and agriculture and metals, including encouraging the regulators to impose position limits, which the CFTC has done. You see additional enforcement authority in particularly with respect to trading practices. So you have additional anti-manipulation provisions and new provisions that govern various disruptive practices that I think are going to change the way a lot of traders have to think about how they do their business. And you have the whistleblower provisions as well that again enhance the authority of the regulators to obtain information and enforce the provisions of Title VII. I would say that's an awful lot of activity to cover. We may have to, we're obviously not going to be able to cover it all, but focusing for the moment on the swap dealer and major swap participant regulations, I think, as I say, Mike and Andy will talk about that in greater detail, but they involve registration of swap dealers, additional margin and capital requirements, record keeping and reporting, business conduct standards, documentation standards, risk management standards, new requirements relating to chief compliance officers and their obligations, collateral management standards, and conflicts of interest provisions. Also important, I think, for those who are who deal in the swaps markets are the Lincoln Amendment, the bank push-out provisions, which I'm not going to talk about in great detail, but require that banks who are engaged in swap dealing activity at least with respect to certain of their instruments, particularly in the non-rate and credit area, are going to be required to do that business in a separately capitalized affiliate rather than in the bank if they want to have access to FDIC insurance or the Fed discount window. There is a little bit of a complication there for foreign banks where the provisions were, I think, drafted poorly. I don't think it was intentional, but they make it more difficult for U.S. branches of foreign banks to push out their swap dealing activity into an affiliate, and there is, and Andy may or may not talk about it, there are some efforts on the Hill to fix that anomaly. Again, just in terms of overview on the mandatory clearing and exchange trading requirements, the way this process will work is the clearinghouses will submit to the regulators those products that they wish to clear. They will have to be approved by the regulators, and then the regulators will have to make a determination as to which swaps products will be required to be submitted to clearing. The estimates are that that could be as much as 70 to 80% of the market eventually, but as yet the regulators haven't designated any particular class or category of swaps to be that must be cleared. The general indications we're getting from the CFTC is that the first designations of swaps that are going to be required to be cleared will come probably this summer or relatively soon, and that will probably start with the plain vanilla interest rate products and some of the credit default swap index products, and we could see those designations, as I say, anytime in the next several months, and then obviously they'll have to set a compliance date by which time those products will have to be cleared, and we expect that to be phased in based on the identity of the parties. So, for example, dealers will have to clear first, followed by financial entities that are not designated as or not registered as swap dealers or major swap participants. There are exemptions, I think, as most of you may know, for various non-financial entities who use swaps to hedge commercial risk. They will be exempt from mandatory clearing if they can make make those showings. The CFTC and SEC are also considering exemptions from mandatory clearing for certain banks and other financial institutions with less than $10 billion in assets, but as yet we haven't seen final end user exemption rules from either agency, so we'll just have to wait and see as to the scope of those exemptions. Along with mandatory clearing comes mandatory exchange trading. If the contract is required to be cleared, it will be required to be exchange traded as well, assuming that the swap is, in the words of the statute, available for trading on an exchange. And it seems pretty clear that available for trading is not going to simply mean be listed on some exchange somewhere. There are going to be some objective standards of determination regulators are going to have to make as to whether it is going to be a product that is going to be required to be exchange traded as well as cleared. But what those standards exactly are is not yet been determined by the CFTC or the SEC, and we, I think the industry is eagerly awaiting those guidances from those two agencies. Now, if the swap is a swap that does not have to be cleared and exchange traded, either because it hasn't been designated as such by the regulators or because it is subject to one of the end user exemptions, the bilateral market will nevertheless, I think, change quite significantly. The perhaps largest change we're going to see, and when Andy gets into a discussion of the Andy or Mike, the swap dealer registration, you'll see other requirements that will apply to the bilateral marketplace. But perhaps the biggest change is going to be in the area of margin. The regulators have proposed but not finalized initial and variation margin requirements for uncleared swaps. I think, again, in keeping with the general objective of encouraging more swaps to be traded and cleared centrally, you're going to see fairly significant margin requirements on the uncleared swaps marketplace. And that means that swap dealers and major swap participants are going to be required to post and collect margin from other dealers and other major swap participants. It means that there'll be significant margin requirements for swap dealers and major swap participants who are trading with high-risk financial end users, which generally means financial funds and other financial institutions that are not swap dealers and major swap participants. And swap dealers under the proposed rules will also be required to collect margin from low-risk financial end users and non-financial end users like corporate hedgers, but they will be subject to certain permissible credit thresholds. So in other words, the swap dealer may be permitted to extend credit to its counterparty to cover the initial margin requirement, but those credit determinations will be reviewed by the prudential regulators as it would other credit determinations made by the institution. I wanted to just briefly mention the Forex markets because those two are potentially subject to quite a significant change. The Dodd-Frank Title VII permits the Secretary of Treasury to exempt certain Forex forwards and swaps from most of Title VII, including the mandatory clearing and exchange trading requirements. And the Treasury Secretary has proposed such an exemption, but he has not finalized those provisions, and it is, I think, fair to say there's some question as to whether they will be finalized or not. If finalized, there still will be a fair amount of the Forex marketplace that will be subject to the new Title VII regime, including Forex options, non-deliverable forwards, and cross-currency swaps. In addition, retail Forex, that is trades with between dealers or others and non-eligible contract participants will be subject to new retail Forex rules that have been promulgated by the various regulators. So, for example, if you're a financial institution wanting to continue to do retail Forex transactions with your customers, you are going to have to comply with recently promulgated retail Forex rules that the prudential regulators have issued over the last year. I mentioned position limits. I don't think I need to spend a lot of time discussing those, but it's for folks who are involved in the physical marketplace, in energy products, in ag products, those are going to be significant. and they're going to apply both to the on-exchange markets as well as the swap markets to the extent those swap products are performing a significant price discovery function. So that's something you need to be aware of. Of course, those position limit rulemaking is being challenged in court, so we'll see what happens with that. Again, enforcement authority, I think I'll skip over for just in the interest of time, but they for those who trade in these marketplaces, it's something people are going to have to be aware of. It makes it much more difficult to distinguish between legitimate and unlawful trading, particularly when you're trading at or near the close of the various marketplaces. Volcker rule, we could spend a whole 2 hours or more discussing the proposed Volcker rule. Both, as I think almost everybody knows, it subjects banking entities, which includes both insured depository institutions and holding companies, as well as non-U.S. banks with branches or agencies in the U.S., to various restrictions relating to its proprietary trading and sponsoring or investing in hedge funds and private equity funds. Again, we have a very extensive proposed rule that has been sharply criticized in comments and is likely to change, but given recent events, it's not quite clear how whether those changes will be for the better or the worse. Maybe that's enough as for background, and we can turn it over to Mike for entity and product definition discussion.
Thanks, Dan. Mike?
Thanks, Dan. All right, so what we're going to look at now are the latest sets of definitions that the SEC and the CFTC have promulgated in the swaps area. And these definitions also define the new registration categories under respectively SEC and CFTC jurisdiction. The first set of definitions are the swaps dealer definitions and the securities-based swap dealer definitions. The second set of definitions we'll look at are the major swap participants and the major security-based swap participant definitions. And we'll start with the swaps dealer definitions and start with the swaps dealer definition that's set forth in Dodd-Frank. And the Dodd-Frank definition of swaps dealer really focuses on the types of activities engaged in by swap parties in connection with their swap transaction activities. And it really sets up four, functional tests or categories of activities, tests that are to be applied in the alternative in determining whether or not, by reason of your activities in the swap markets, you are a swap dealers. And the first test is whether or not you engage in activities in the swap markets which would constitute holding yourself out as being a dealer. The second test, which is somewhat similar to the first test, is whether or not you engage in activities which in the swaps markets which cause you to be known to the trade or industry in the swaps markets as being a dealer or market maker. The third test is whether you engage in market-making activities in the swaps markets. And the fourth test is whether or not in entering into swaps transactions, you're entering into those transactions for your own account in the ordinary course of your business. The statute also includes an exception from the swaps dealer concept, which is really closely related. It's kind of the flip side of the fourth test. And so the statute provides an exception from swaps dealer status for persons who enter into swaps transactions for their own account, either individually or acting as a fiduciary, but who are not entering into those transactions as part of a regular business. The statute also directs the SEC and the CFTC to establish a further exception from the swaps dealer concept for persons who, although they engage in dealer activities in the swap markets, nevertheless who engage in such a small amount of dealer activities as not to warrant registration and regulation as a swaps dealer. In the final rules that the SEC and the CFTC recently jointly released, the final definitions really track the statutory definition very closely. The final definition incorporates the four-prong activity test from the statute. It also incorporates the statutory exemption from the dealer definition for persons who engage in swap transactions for their own account, not as part of a regular business. And under the final rules, the SEC and the CFTC have established the de minimis exemption mandated by the statute to accept from the dealer definition persons whose total swap activities over a 12-month look-back period don't exceed certain objective notional thresholds. And initially, that threshold has been set at $8 billion, but it's been set initially as part of a phase-in program, and what's contemplated is that eventually it will phase down from an $8 million cap to a $8 billion cap to a $3 billion cap at over at most 5 years. It's not clear whether that could happen in stages, whether or not we're going to go through a period, which I think is probably more likely, where the agencies are going to gather a lot of information from the swaps data reports that they receive and the registrations that issue about the swap markets to make determinations as to where that level should be set. In adopting the final definitions, although the commissions and comments were encouraged to adopt certain entity classification exceptions from the swap dealer definitions, for example, for pension plans or agricultural cooperatives or otherwise regulated entities, they declined to adopt any blanket entity exclusion from the definitions. Also, other than establishing the de minimis exception, they declined to establish any additional thresholds of swaps activities that would be relevant to making a dealer determination. So they've really tracked the statute quite closely and incorporated the four-prong activities test. And really what we have in the final definitions is a very facts and circumstances type of test, which has a fair amount of nuance, subjectivity, and judgment involved. The rules and the release accompanying the rules really provide an analytical framework within which to make the determination as to whether or not one's activities in the swap markets constitute dealing activities. There's the release includes a lot of guidance from the commissions with respect to examples and various activities, factors that the commissions are suggesting should be weighed and considered in making a determination as to whether or not your activities constitute dealing activities. And you know, and the factors and examples are provided or are designed to help people make determinations as to whether or not the activities are market making or dealing activities, whether the activities constitute holding oneself out, or the activities that cause one to become known as a dealer in the business, whether the activities are undertaken as part of an ordinary course of business or as part of the conduct of a regular business, or whether they're not. Particularly in the area of market making and dealing, but also with respect to holding out, the commissions really are relying a lot upon the law and the lore that has developed in the securities industry over the years in the broker-dealer context with respect to the dealer-trader distinction. And in that context, the distinctions ought to be made is the difference between a securities dealer and someone who's in the market as a securities trader or investor. And the commissions have indicated that they're really going to look to that developed body of law and lore in making their assessments as to swap dealer status. In the final rules, the commissions also have included exclusionary rules. That is, rules by which in making your dealer determinations, there are certain types of swap activities associated with particular types of swap transactions which you can ignore for purposes of your analysis. These include swaps between majority-owned affiliates, swaps between cooperatives and their members, swaps which are entered into for what I call bona fide hedging purposes. This is not merely risk mitigation, but bona fide hedging purposes, certain floor broker swaps, and in the case of the CFTC's MSP definition, swaps entered into by an insured depository institution in connection with loan originations. So the basic approach to the dealer determinations under the final rules is to look at the types of swaps activities you engage in. Again, only looking at those swaps and activities after you've excluded the swap transactions that are excludable from the analysis. Then apply the four-pronged test to determine whether any of those activities constitute a dealing activity under one of the four tests, and if they fall under any of one of the four tests, you would constitute a dealer, unless your third step is to apply the de minimis exemption to see whether or not your total swaps activity exceeds the de minimis threshold cap. As I said, the release includes a lot of guidance and includes a lot of examples and factors to be considered. None of the examples and factors constitute an exclusive or exhaustive list. None of them by themselves are determinative. When you go through the factors in the different categories, a lot of them seem to kind of overlap from test to test. And you kind of really, get the sense that this flexible facts and circumstances test is one which the commissions believe gives them the leeway going forward to make determinations kind of on a, not a case-by-case basis, but on a kind of a unshackled way about what constitutes swap dealers. And there's almost kind of this sense that at least I had that from the releases that, in the Commission's views, they'll know what a dealing activity is when they see it. As I said, there are a whole bunch of factors, and I don't know that we really have time to go through all the cited factors, but to give you a flavor for some of them as it relates to dealing activity, the commissions are going to look at whether you're providing the role you're providing in the market is one of providing liquidity, whether you're there to accommodate someone else's demand or needs to enter into a swap transaction, as opposed to whether you're entering into that transaction for your own account, for your own business needs, whether you advise other people with respect to swaps transactions, the structuring of the transactions, the use of the transactions for hedge, whether you're providing price quotes, whether you maintain a customer base, whether you're soliciting customers, whether you carry a separate P&L in your financials for your swaps activity, whether you maintain dedicated staff related to your swaps activity, typically staff in terms of customer dealings, counterparty dealings, credit determinations, collateral monitoring, collateral valuation, documentation. In the holding out area, factors that they mentioned include whether or not you are actively soliciting indications of interest from counterparties for swap transactions, whether or not you regularly engage in developing new swaps products, modified swaps products, and then communicate to the industry that you are available to enter into these products. They're also going to look at whether or not, in certain trade associations like ISDA, whether or not you hold a dealer membership category, and they think that's indicative of holding oneself out. They also provide a number of factors and examples related to distinguishing whether or not your swaps activity is undertaken in connection with, in the ordinary course of business, as part of a regular business, which seem to be somewhat synonymous, or whether it's being undertaken but not part of a regular business. And again, they're going to look at some of the same factors there. I mean, they're really trying to determine whether or not you are engaging this as part of an identifiable business. They're going to look at things like the separate P&L, whether or not you have maintain a swaps staff and swaps personnel, and they're going to look at the reasons why you're entering into the markets, whether is it to accommodate somebody else or is it for your own business need. A couple of points on the de minimis exemption. As I said, it's a phase-in. Initially, the cap is set at $8 billion, and moving down to $3 billion. And as with the four-prong test itself, in calculating the total amount of swap activity you have, you ignore all the excludable swap transactions that you did for the four-prong test. And with respect to the hedging exemption or exclusion in the swap dealer calculation, I just note that it's pretty narrow. It pretty much tracks the new bona fide hedging exemption in the new position limit rules under 151.5, and it's really focused on whether or not the swap position is intended as a substitute for physical. Okay, so next, let's take a look at the major swap participant and major security-based swap participant definitions. Again, starting with the statute, you will be deemed to be a major swap participant if you're not a swaps dealer or a securities-based swaps dealer, and then if you satisfy one of three tests, and these tests are really all, to one degree or another, focused on the size of the positions that you maintain in the market. So it's really unlike the dealer definition, which is only looking at activities. The first test is the substantial position test, and if you hold a substantial position in any major swaps category, excluding hedging or risk mitigation swap transactions, you're going to be deemed to be a dealer. Second test is a substantial counterparty test. If the amount of the swaps or securities-based swaps that you hold could create a substantial counterparty exposure that could adversely affect the stability of the U.S. banking system or financial markets. The third test is the leveraged financial entity test. If you're a financial entity that's highly leveraged relative to capital, you're not subject to bank agency prescribed capital requirements, and you hold a substantial position in any major swap category, similar to the first test, although for purposes of this test, all positions are included, including all hedging and risk mitigation provisions. The final rules promulgated by the SEC and the CFTC, again, really closely track the statute. They include the alternative three-prong test, and the final rules set the threshold levels which are open in the statute for determining whether or not you fall subject to registration under any of the three tests. The first thing you have to understand in terms of applying the test are three really building blocks that the commissions have set up for purposes of applying the test. And the first is the designation of major swap categories, and 6 major swap categories have been designated. 4 on the CFTC side: rate swaps, credit swaps, equity swaps, and a catch-all commodity swaps. And 2 on the securities, the SEC security side, which are debt securities-based swaps. The first, and the second is securities-based swaps, which is a catch-all. The second building block really is the creation of something called a uncollateralized exposure test. And the purpose of this test is to measure what the amount of your net open uncollateralized swap exposure is with respect to a particular swap position if the transaction were to terminate. There are no particular valuation methods prescribed under the rules for either valuing collateral or the value of the swap. It's assumed you're going to follow your current industry accepted standards of valuation. And the basic calculation is really pretty simple. You take the total for each swap position in each major category. You take the total value of the swap, you subtract or net out the value of the collateral, and for this purpose, non-cash collateral is also good as long as the counterparty would have access to it. And then you get to further net your exposure if the swap is subject to a master netting agreement. The third building block is the potential future swap exposure test, and the purpose of this test is to quantify what, as opposed to your current exposure, what your future exposure might be under a swap transaction over the life of the transaction and with the variation in market valuations. It's kind of more of a long-term component. It's a complex calculation. The basic calculation is, again, starting with each swap transaction. You start with the notional value of each swap, and the notional value would take account of any inherent leverage in the swap. And then you multiply that notional value by a specified risk factor, depending on the type of swap it is, and they range from 0.5% to, say, 15%. And then you get to further reduce your exposure calculation depending on the terms of the swap. So if it's subject to mark-to-market margining, you get to reduce it by 80%. If it's subject to central clearing, you get to reduce it by 90%. If it's subject to master netting, you get to reduce it by up to 60%. And so under that calculation, and there are a bunch of special rules as well, you basically come up with this this exposure number of your potential future swap exposure for each transaction. So then quickly looking at the three actual tests themselves under the rules. Under the first test, the substantial position test, you're going to be deemed to be a major swap participant by the CFTC if the daily average of your uncollateralized swap exposure in any major swaps category is at least $1 billion, or $3 billion in the case of rate swaps. Or two, if your daily average uncollateralized swap exposure combined with your potential future swaps exposure in any major swaps category is at least $2 billion or $6 billion in the case of rate swaps. For SEC purposes, you'll be deemed to be a major swap participant if your daily uncollateralized exposure in a major securities-based swap category is at least $1 billion, or if your daily uncollateralized exposure plus future exposure in any major securities swaps category is at least $2 billion. It's a quarterly calculation based on quarterly data. It's made separately with respect to all the positions in each swap category, although for the substantial position test, you again don't include hedging and risk mitigation positions. And moving on to the second test, which is the substantial counterparty exposure test. Under this test, again using the building blocks, you'll be deemed to be an MSP by the CFTC if your daily average uncollateral swaps exposure is at least $5 billion, or your daily average uncollateralized swaps exposure combined with your potential future swaps exposure is at least $8 billion. And under the SEC rules, it's a $2 billion, $4 billion formula. Now, this calculation it's also a quarterly calculation, but it's a calculation that aggregates all swap positions in all categories. It's not a by-category calculation. It's an aggregate of all positions. It includes hedging and risk mitigation. There are really no exclusions. The only thing is you calculate it separately for CFTC and SEC purposes with respect to the respective swap categories. The third test is the highly leveraged financial entity test. So the first prong of which is you're a financial entity, and this includes commodity pools, private funds, ERISA plans, banking and financial entities, and you're not subject to federally prescribed bank capital requirements. And your liability to equity ratio, determined under GAAP, is greater than 12-to-1. If you meet all three of those conditions and you hold a substantial position in any major swaps category, you would meet the requirements of the third test. And again, unlike the first test, the substantial position test, in calculating substantial position with respect to a major swaps category for this test, you include all hedging and risk mitigation positions. Again, there are a bunch of special rules and attribution rules which could be applicable depending on the parties and the transactions, and but that's kind of the basic test. Just a quick word on registration. There are no registration deadlines yet. Both the commissions acknowledge that what the ultimate registration deadline will be is dependent upon further rulemakings to come. In any event, it's not going to be earlier than 60 days after the final swaps definition is finally issued. Although there's no deadline, on the CFTC NFA side of things, since January, you've been able to submit applications for registration as either a swaps dealer or an MSP, and you can obtain a provisional registration. Ultimately, obtaining full registration requires your demonstration of compliance with a whole bunch of conduct rules and capital rules which have yet to come. but you can start out by filing your basic registration application on behalf of the firm and all of the principals of the firm who have to individually submit application forms. And then as the compliance rules roll out, you'll have an opportunity to demonstrate. You'll have to demonstrate your compliance with those rules or your registration will lapse. To date, not a single application has been filed for registration as either a swaps dealer or a major swaps participant. I don't think it's just because of the $15,000 fee. I think people are expecting maybe that will start to change. On the SEC side, in October, the SEC promulgated some registration rules, including a form, SBSE, I think it's called, which is modeled after the broker-dealer form. The comments have been received. There haven't been final rules issued, and there is no provisional registration process that's available on the SEC side currently.
Thanks, Mike. Dan's going to talk about some extraterritoriality issues now. Thank you.
Yeah, as I think people are getting a flavor for, the Title VII impacts swaps activity in really across the board, whether it's registration and all the requirements that will be applicable to dealers and major swap participants, or how the trade is executed, how the trade is cleared, how the trade is reported. And as a result, it raises the obvious and important question, well, to what extent do these rules apply cross-border? What is the scope of Dodd-Frank with respect to extraterritoriality? And what do you do about a statute that is attempting to regulate a market that is truly global and truly international, and where so much of the activity is conducted between folks that are in the U.S. and folks who are out of the U.S., or markets that are located outside the U.S., but that may have some impact on U.S. entities and the U.S. economy. So these issues are naturally extremely important, and what we have so far is very little guidance. The statute itself in Section 722 states that the provisions of Dodd-Frank relating to swaps do not apply to activities outside the U.S. unless those activities have a direct and significant connection with activities in or effect on the commerce of the U.S. Good luck trying to figure out what that means. Or if they contravene such rules or regulations as the CFTC may prescribe as are necessary or appropriate to prevent the evasion of the act. So the anti-evasion authority as well. The SEC provision on extraterritoriality for some reason is more limited. It doesn't have the section on the direct and significant connection with U.S. commerce, but most people think that's probably just an oversight, and I doubt that you're going to see significantly different extraterritoriality interpretations from the two regulators, but that remains to be seen. Hopefully, it remains to be seen relatively in the relative near future. We're expecting guidance, at least from the CFTC and possibly from the SEC, within a matter of weeks, and certainly I think within the next month or two. And I think folks are eagerly awaiting that guidance. Talking about sort of general principles, we do have some. I think we can make some educated guesses about where this is headed with respect to extraterritorial application. General principles, it's going to apply to U.S. persons when they are transacting, and it is likely to apply to swaps involving U.S. persons when they are one of the parties to the transaction. It is likely to apply to swaps that are executed in the U.S. and swaps that are cleared in the U.S., although there are maybe some exceptions to that rule in that the CFTC, for example, has indicated that simply because a swap is cleared in the U.S. involving two non-U.S. persons does not mean that you would have to count that swap against your de minimis threshold, for example, in the dealer registration rules that Mike has just described. But assuming that general principle, if it's a U.S. person involved, it's going Dodd-Frank will apply. What does it mean to be a U.S. person? That's a big issue here. Generally, U.S. Persons will include natural residents, resident in the natural persons resident in the U.S., and partnerships and corporations organized or incorporated under the laws of the U.S. But how will Dodd-Frank treat branches or affiliates of U.S. persons who are located overseas? And what will Dodd-Frank do about branches or divisions of non-U.S. persons that are based in the U.S.? Those are very big questions that have received a lot of comment and are, I think, being actively debated within the agencies. Generally, prior to Dodd-Frank, folks who were organized outside the U.S. and doing business with non-U.S. persons would not be subject to the securities or commodities laws, with certain exceptions. But U.S. regulators in the Dodd-Frank context have expressed some concern that it would be too easy for U.S. persons to evade Title VII regulation given the fluid nature of the swaps market by simply booking their swaps through non-U.S. affiliates. And Chairman Gensler has recently given a speech indicating that he is also personally concerned that the risks of non-U.S. affiliates of U.S. persons will ultimately be borne by the U.S. parent if there is another financial crisis, and that, to him, is another reason why the rules have to be applied broadly in this context. So let's talk for a minute about the status of branches or divisions of non-U.S. persons who are located in the U.S. So this is for example, a non-U.S. bank with a U.S. branch. Generally, I think it's fair to say that entity, if it's involved in swaps activity, will be regulated, but a much bigger question will be, does that subject the entire non-U.S. entity to Title VII regulation? And how about non-U.S. persons who are dealing with U.S. customers? That is, the foreign bank dealing directly with U.S. customers. To what extent will that subject the entire non-U.S. entity to full swap dealer or major swap participant regulation? And I think the next important question to ask is, again, along those same lines, will the U.S. regulators be willing to apply their rules selectively? That is, apply certain rules, perhaps under Dodd-Frank, while deferring to the home country regulator with respect to other rules. The other issue that I think you see that become very challenging in this context is the mandatory clearing and exchange trading rules. As we've seen, Dodd-Frank requires that that standardized swaps involving financial entities be cleared and be exchange traded. To satisfy that requirement, the U.S. swap dealer or swap trader is going to have to execute or clear those at facilities that are registered by the U.S. regulator. But unfortunately, most of the G20 countries are likely and are expected to impose similar requirements on their entities. And how, in a world of cross-border business, where you have both regulators insisting that you clear and execute through their regulated entities. How is that going to work? And I think that's a big question that is going to require some harmonization and cooperation among international regulators. The same would go for trade reporting. There's no question that we're going to see and have seen, and Andy will describe, the trade reporting rules that will apply to all swaps. They'll be required to report those swaps to swap data repositories in the U.S. with respect to swaps that are covered by the Dodd-Frank Title VII. But those same requirements will apply in all likelihood overseas as well in terms of reporting to overseas swap warehouses. So how do the entities in cross-border transactions comply with the reporting rules, particularly where the reporting rules may not be identical and indeed may differ significantly. So again, major problem of harmonization and consistency. Well, what's the latest intelligence? Where do we think the Commission is going? Chairman Gensler recently gave a speech that indicated that the CFTC staff is prepared to recommend the following approach. Again, until we see final rules, we have no idea if that's what's going to come out of the Commission, but here's some guidance as to where I think the chairman at least is thinking about these issues. First, foreign entities that conduct swap dealing activity with U.S. persons above a certain de minimis level are going to be required to register with as swap dealers with the CFTC. So if you're a non-U.S. person but you're dealing with U.S. persons above a threshold, you're going to have to register. U.S. persons are likely to be defined to include overseas branches of U.S. persons. So your overseas branch of a U.S. bank will be viewed as a U.S. person. That will be U.S.-facing swap dealing. And overseas affiliates of U.S. persons that are guaranteed by the U.S. entity. So again, non-U.S. bank trading with non-U.S. affiliate of U.S. person but with a U.S. guarantee, that's going to be viewed as covered by Dodd-Frank. It also, and interestingly, will include in the chairman's view overseas affiliates of U.S. persons who are operating as, quote, conduits for the U.S. entity swap activity. That's one that I think we're going to have to await the final guidance as to what they mean by conduits and how they will define that, but that is I think, quite significant, and we'll just have to see how that plays out. CFTC regulation of non-U.S. dealers will vary based on whether the regulations are entity-level regulations or transaction-level regulations. And what I mean by that is, and what is commonly meant by that is that entity-level regulations are ones that apply across to the entity as a whole, such as capital, record-keeping, risk management standards, while transaction-level regulations apply to particular transactions, clearing, margin, trade execution, sales practices. It's not necessarily a perfectly clear line, but that's the notion. And according to the chairman, entity-level requirements may well be complied with through substituted compliance with comparable home country regulations. So basically what that means is, I don't know how many of you are familiar with the Part 30 rules that govern foreign futures trading by non-U.S. people with U.S. persons, but basically if the non-U.S. entity dealing with U.S. persons can demonstrate that their home country regulations with respect to the the entity-based requirements such as capital and risk management standards is comparable to the Dodd-Frank requirements, that the CFTC or the SEC may well essentially defer to those home country requirements and allow you to comply with the Dodd-Frank requirements through your compliance with the home country rules. The chairman made clear that the U.S. transaction level requirements would apply to all transactions with U.S. persons, though. So if it's a transaction level requirement and you're a non-U.S. bank dealing with a U.S. person as defined earlier, then you're going to be subject to the Dodd-Frank rules. But that the U.S. transaction level requirements would not apply to overseas swap dealers, including affiliates of U.S. entities, if the counterparty are not U.S. persons, and they're not conduits for U.S. persons, and they're not guaranteed by U.S. persons. So that's the level of guidance we've received so far. Again, until we see the actual rulemaking, we don't know whether that's going to be accepted at the commission level, but that is the staff recommendation according to the chairman.
Thanks, Dan. Then we're going to talk to Andy's going to talk about the record keeping and compliance requirements.
Okay. Good afternoon. Thank you. Thank you, Dan. Thank you, Mike. And thank you, Kathleen. Before we get into the nitty-gritty here, and there would be a lot of nitty-gritty because what we are now embarking on is basically an entire new regulatory system for swaps. Before getting into the details, let me first state that there isn't really any way that we would be able, in the time allotted to us today, to give full details about what is going to be expected for swap market participants in the future. So what I thought I would do today is, before getting into the slides, I'd like to go over three basic themes. And especially if you're new to this, like if you're a new associate someplace in a law firm, or you're a new compliance officer, or you're just bewildered by the amount of releases and the volume of materials that are coming out from the federal regulators, what I'd suggest you do is this. There are three basic themes that I'd like to get across today, and what I would like to leave you with is this. If you can keep these themes in mind, you're probably going to get to the right answer when you get to a question about record keeping or the compliance burdens that you're going to face in the future. Again, these things are not yet in effect. We don't have a definition of the word swap yet. When that comes out, we can start. We can expect to see things start to roll. The first theme that I would like to stress to everyone out there is transparency. What the regulators, and all of these things are things that the regulators want to do. The first thing, overarching all of them, is transparency. The regulators want this market to become possibly the most transparent financial services market that has ever been put into place. And they want this transparency to apply not only for market participants, but for the regulators themselves. So if you have a record-keeping question, or you have a reporting question, just ask yourself this. Is the answer going to make the market more transparent, or will it give the regulators more information? In general, your answer is going to be driven by the answer to that question, which is yes. It's going to have to become more transparent, and you are going to have to keep more records than you've ever kept before. The second major theme, and this goes back to things that Dan was talking about at the beginning, is one of customer protection. We are now going to see a load of new regulations adopted, and which we'll see illustrated in the slides that are coming up, that are intended to protect customers. And for example, I'm going to talk a little bit about what's called a special entity. A special entity gets special protections under the new rules. The third major theme that I would like to talk about is the preference for exchange trading and central clearing. That's the third goal the regulators are trying to get at here. Whenever possible, they want swaps on markets, they want on exchange, they want on DCM or SEF, and they want it centrally cleared. the goal here, at least they've said, is to get about 80% of the market onto these market utilities. At most, that means they're going to tolerate, say, 20% of the market out there being done the way it's done today. So if you think about that and realize that, well, 80% of your life is now going to change, this is a very, very significant volume of regulations that are coming out. So now, obviously we can't cover every one of those. I have to speak closer to the microphone. I might have to swallow it. Okay, let's talk about the first slide. We're never going to be able to go through all the new record-keeping rules, are we? But we can illustrate what we mean here. Full trade reconstruction is the goal of the CFTC. Let me repeat that again. Full trade reconstruction. Daily trade records, records of complaints, obviously that goes beyond individual trades, but records of filled, records of unfilled orders, records of oral and written communications regarding bids, offers, trading, prices, records of transaction reporting, all to be preserved. Records relating to positions to be linked with the daily trading records must also be preserved. And in order to make things as transparent again as possible for the regulators, the records have to be searchable. Searchable by transaction, searchable by counterparty. A few little bits of information here. Compliance dates, you can see that from the slide. 5 years, 2 years in the first year, the first 2 years in a readily accessible place. And the location has to be at the principal place of business. Let's talk about something here that I think is pretty significant. Telephone calls. Once upon a time, telephone calls did not have to be recorded, but market participants recorded their telephone calls for purposes of recording the accuracy of trading information. Well, the CFTC has determined now that if certain information, such as quote information, price information, any information that relates to the execution or entry of an order is on a telephone, it will have to be recorded. So unless you are trading exclusively by electronic or screen-based means, there will have to be recording facilities now installed on systems, and the recordings will have to be maintained for a designated period of time. The designated period, unlike regular records, is only going to be 1 year. Nonetheless, this is a very, very significant and important compliance obligation that swap dealers and major swap participants will all have. But again, you can see now what we're talking about, the depth of transparency that's going to be required, and the record-keeping obligations that the regulators are seeking to impose here. If, as you can see again, if it will make the market more transparent and understandable to the regulators, that record is going to have to be kept. Let's talk about making the market more transparent to regulators, not just on a record-keeping basis, but on a reporting basis. Records are kept so that they can be inspected. Reports are made so that they can be filed, and the regulators can see what's going on at your firm. There will now be, for swap dealers and major swap participants, reporting obligations on a monthly, on a quarterly, on a yearly, and on episodic basis. You can see what here from the slide, a very, very quick summary. Unaudited financial statements and annual audited financial statements, unaudited financial statements, it's a monthly reporting obligation. Audited financial statements must be provided yearly. Risk exposure reports, which will be part and parcel of new risk management programs or new required risk management programs, will also have to be filed with the CFTC. These are going to have to be filed quarterly and immediately upon detection of any material change in risk exposure. Last, an annual compliance report prepared by the Chief Compliance Officer signed and certified, presented to the board and senior officers. Risk management programs, as I mentioned before, there will have to be a risk exposure report requirement. This is part of a risk management program requirement. All of those things have to be, the plan, the risk management plan, will also have to be filed with the CFTC. Well, we've talked a little bit about making things transparent for regulators. Let's talk about making things transparent for the market. We now have new real-time public reporting rules for swap transaction data, and there are similar SEC proposals that are currently pending. By now, we've all heard of swap data repositories. At present, there are no swap data repositories that are registered. There are 3 that have applied for registration with the CFTC. And when they go online, we can expect to see a unprecedented level of depth into the marketplace. The details here about all of the facts that will have to be provided to a swap data repository on any swap that is executed, well, you can see somewhat here what they are. Without getting into the details, I think that the thing to stress is this. Although this information will now be publicly available, the burden on a swap dealer and a major swap participant will be greatly reduced whenever it executes a transaction on a facility, on a SEF, on a DCM, and whenever the transaction is centrally cleared. In this fashion, the goals of the regulator, which are to promote exchange trading, can be fostered. Few other details here about trade reporting, matters that are kind of left open for the future. The International Organization for Standardization is currently working on a legal identifier system by which swap dealers and major swap participants will be assigned legal entity identifiers so that transactions can be mapped. Until those standards are complete and until the regulators have recognized some entity for the assignment of legal entity identifiers, legal entity identifiers in swap transactions will be assigned by swap data repositories, as will in general product identifiers. Again, we do not have effective regulations. What we have are compliance dates set sometime in the future after the term swap has been defined. The dates here are set out in this slide. 60 days after the joint SEC and CFTC rules that define the term swap is when the magic will begin to happen. Dan mentioned customer protection at the beginning. The new market is going to have increased amounts of customer protection. And what I would like to also point out here is that compliance burdens, again, can be eased by executing transactions on SEFs and DCMs. Again, we're trying to promote exchange trading and central clearing. So if a transaction is executed on a SEF or a DCM, things like know your counterparty obligations, verification of swap eligibility, disclosures, things like that, are not as are not going to be as burdensome. You can see here that swap dealers are going to, in general, have new know your counterparty standards to comply with. These will include obtaining facts similar to a suitability obligation to the suitability obligations that currently apply to broker-dealers in the securities markets. Suitability obligations that go beyond know your customer requirements will be triggered whenever there's a recommendation by a swap dealer to a party other than some other form of swap entity. For those that are not familiar with the FINRA or SEC standards for suitability, this will require gathering information about counterparties and to some extent determining that there is a reasonable basis to conclude that the transaction that is recommended for that counterparty is actually suitable for the counterparty. Special entities, as I mentioned above, as I mentioned before, are entitled to certain enhanced protections. Special entities are in general governmental entities and employee benefit plans, as well as endowments. These type of entities will get special protections that are required of swap dealers and major swap participants that act either as advisors or as counterparties to these types of entities. Disclosures, which previously have not been so tightly defined and tightly required, have been enhanced substantially. Prior to entry into a swap, there's going to have to be disclosure of material information for counterparties so that they can assess risks, swap terms, conflicts, in market, and clearing rights. One of the more interesting changes is the requirement for a scenario analysis. In a transaction between a swap dealer and a customer, customers will be allowed to request a scenario analysis to show, well, basically how things will pan out under a given range of circumstances. However, if the transaction is executed on a SEF or on a DCM, this requirement will not apply. Again, we're trying to promote exchange trading. With the last few minutes, I'd just like to point out a few other things. A new Chief Compliance Officer requirement has been adopted by the CFTC. The new Chief Compliance Officer will have to be appointed by and report to the Board of Directors or the senior officer. In addition, their compensation must be approved by either of the board or the senior officer, and they will only be able to be removed by the board or the senior officer. The CCO is going to have many burdens. They'll have to develop compliance policy, and they will have to conduct a yearly minimum meeting with the board and to prepare and sign the annual compliance report that will be required to be filed with the CFTC or SEC as appropriate. Last, very quick slide was just explain some of the basics that are also going to be required. There will be a new supervisory management program that each swap dealer and major swap participant must adopt, and there must be an additional conflicts of interest policies that are designed to address the conflicts that are faced by research analysts and those involved in an entity's clearing divisions. That said, I think we are just about out of time. Thank you, and I'd like to turn it back over to Kathy and end it here.
Thank you. Thank you so much, Andy. We do have a couple of minutes for a couple of questions, if anybody has any. I'm looking at the chat room. I don't see any. Right now. But as you can tell from the last slide, we have the contact information for all of our speakers today. So please feel free to send them questions. But if no one has any other questions at this point, I'd like to thank the panel very much. There's a lot of information, as you can tell, but a lot of it's to be continued. And so keep your eye peeled sort of on the Arnold & Porter website. We try to keep everyone up to date on what's going on with Dodd-Frank. And I want to thank everybody again. And if you have any other further questions, please feel free to contact us. Thank you. Have a nice day.
Registration of swap dealers, additional margin and capital requirements, record keeping and reporting, business conduct standards, documentation standards, risk management standards, new requirements relating to chief compliance officers and their obligations, collateral management standards, and conflicts of interest provisions. Also important, I think, for those who are who deal in the swaps markets are the Lincoln Amendment, the bank push-out provisions, which I'm not going to talk about in great detail, but require that banks who were engaged in swap dealing activity, at least with respect to certain of their instruments, particularly in the non-rate and credit area, are going to be required to do that business in a separately capitalized affiliate rather than in the bank if they want to have access to FDIC insurance or the Fed discount window. There is a little bit of a complication there for foreign banks where the provisions were, I think, drafted poorly. I don't think it was intentional, but they make it more difficult for U.S. branches of foreign banks to push out their swap dealing activity into an affiliate, and there is, and Andy may or may not talk about it, there are some efforts on the Hill to fix that anomaly. Again, just in terms of overview on the mandatory clearing and exchange trading requirements, the way this process will work is the clearinghouses will submit to the regulators those products that they wish to clear. They will have to be approved by the regulators, and then the regulators will have to make a determination as to which swaps products will be required to be submitted to clearing. The estimates are that that could be as much as 70 to 80% of the market eventually, but as yet the regulators haven't designated any particular class or category of swaps to be that must be cleared. The general indications we're getting from the CFTC is that the first designation following the financial meltdown of 2008 and 9, there was general consensus among policymakers in Washington, I think, that the largely unregulated OTC derivatives market had contributed in some way to the crisis and to the need for the financial taxpayer bailouts. And as a result, one of the principal objectives of the Dodd-Frank Act was to regulate the swaps and derivatives markets more effectively, and that effort you see reflected in Title VII. It's over 100 pages of legislation that is in almost every section calling for further implementing regulations from the various regulators, principally the CFTC, SEC for securities-based swaps, and the prudential regulators vis-a-vis the financial institutions that they regulate. The central principles of Title VII, I would say, fall within sort of four categories. The first objective or principle is to impose a comprehensive regulation over swap dealers and major swap participants. These are the largest and most active participants in the swaps market, and there was felt to be a need to regulate them in a relatively comprehensive fashion with respect to their swaps activities. And you will hear from both Mike and Andy a good deal about how those provisions are being implemented. The second important objective of Title VII, again reflected throughout that title, is an interest in policymakers in moving the primarily bilaterally negotiated swaps market into clearing or through clearinghouses and onto exchanges. So essentially to require additional clearing and exchange trading of swaps particularly obviously those that are amenable to clearing and exchange trading, which would be the standardized and most liquid of the swaps products. The third, I think, general objective of Title VII is increased transparency both to the public and to the regulators, and you'll see that reflected in a wide variety of provisions in Title VII. I think clear fact was that the market was too opaque, particularly in times of crisis, and as a result, you'll see a lot of new reporting requirements. And the final category, maybe more of a catch-all category, is enhanced regulatory authority to the regulators. Again, perception was that the derivatives markets generally were not being adequately supervised. It wasn't enough oversight by the federal regulators. And there are provisions that enhance that regulation in a variety of ways. There are a lot of new rules applying to existing exchanges and clearinghouses, including rules that permit the FSOC, the Financial Stability Oversight Commission, to get involved where the clearinghouse is viewed as systemically significant. You also see additional oversight over the physical commodity markets, energy and agriculture and metals, including encouraging the regulators to impose position limits, which the CFTC has done. You see additional enforcement authority in particularly with respect to trading practices. So you have additional anti-manipulation provisions and new provisions that govern various disruptive practices that I think are going to change the way a lot of traders have to think about how they do their business. And you have the whistleblower provisions as well that, again, enhance the authority of the regulators to obtain information and enforce the provisions of Title VII. I would say that's an awful lot of activity to cover. We may have to, we're obviously not going to be able to cover it all, but focusing for the moment on the swap dealer and major swap participant regulations, I think, as I say, Mike and Andy will talk about that in greater detail, but they involve
my name is Kathleen Scott, and I'm a counsel here at Arnold & Porter's New York office, and I would like to welcome all of you to our latest in a series of financial services regulatory roundtables. Today it's not just registration, new regulation of swap transactions by U.S. and non-U.S. banks under Dodd-Frank. I need to read a disclaimer. For those who are participating via web, please use the chat feature tool within WebEx to ask questions throughout the program. If we have a chance, we'll take them during the presentations. If not, we'll answer them at the end. If for some reason we run out of time and we can't get to your question, we will answer the question afterwards because you should have all of your contact info. Your lines have been muted. However, if you ever need assistance during the conference, you can just press star, then 0 on your telephone, and a conference coordinator will be happy to assist you. This event is being recorded and will be posted on the Arnold & Porter website, where it will be available to the public. So anybody who speaks will be recorded. And for your convenience, shortly after the program, we will send a link with the presentation materials to all of the participants in today's program. So we have a lot of ground to cover. So I am just moderating and keeping things running on time. My colleagues here today are three people who definitely are in the know about all of these things that are going on. Title VII of Dodd-Frank, dealing with swaps and derivatives, makes sweeping changes to the law, and it's been a topic of interest and great interest in the financial services community. My colleagues today, to my immediate right, is Andy Scheip. He's a counsel in our financial services group. Next to him is Dan Waldman, a partner in our DC office with a derivatives expert. And last but not least is Mike Griffin, a partner here in New York, who is hedge funds expert. So we have some slides, and as you can see, we have the agenda, basically sort of a rough agenda. We'll go through the background, and then entity and product definitions, some extraterritorial issues, and an overview of record keeping, reporting, and compliance issues. So without further ado, I'm going to turn it over to Dan Waldman, who's going to start us off with background.
Good morning. Issues of swaps that are going to be required to be cleared will come probably this summer or relatively soon, and that will probably start with the plain vanilla interest rate products and some of the credit default swap index products. And we could see those designations, as I say, anytime in the next several months, and then obviously they'll have to set a compliance date by which time those products will have to be cleared, and we expect that to be phased in based on the identity of the parties. So, for example, dealers will have to clear first, followed by financial entities that are not designated as or not registered as swap dealers or major swap participants. There are exemptions, I think, as most of you may know, for various non-financial entities who use swaps to hedge commercial risk. They will be exempt from mandatory clearing if they can make make those showings. The CFTC and SEC are also considering exemptions from mandatory clearing for certain banks and other financial institutions with less than $10 billion in assets. But as yet, we haven't seen final end-user exemption rules from either agency. So we'll just have to wait and see as to the scope of those exemptions. Along with mandatory clearing comes mandatory exchange trading. If the contract is required to be cleared, it will be required to be exchange traded as well, assuming that the swap is, in the words of the statute, available for trading on an exchange. And it seems pretty clear that available for trading is not going to simply mean be listed on some exchange somewhere. There are going to be some objective standards of determination regulators are going to have to make as to whether it is going to be a product that is going to be required to be exchange traded as well as cleared. But what those standards exactly are is not yet been determined by the CFTC or the SEC, and we, I think, the industry is eagerly awaiting those guidances from those two agencies. Now, if